Welcome to EUPrivacyForAll, Session 22 on GDPR, Transfers by way of appropriate safeguards, Article 42. Data transfers could be framed by appropriate safeguards as laid down in Article 42. European Parliament suggested two provisions that we could focus on. That a European data protection seal would be granted and frame appropriate safeguards. Binding corporate rules could also be used without any prior authorization. European Parliament also suggested that the currently used authorizations provided by a supervisory authority shall remain valid until 2 years after the entry into force of this regulation. On its side, EU Council suggested that usage of appropriate safeguards should be valid only if also framing onward transfers. It created two buckets: the usage of appropriate safeguards to be assessed without prior authorization, using tools such as legally binding and enforceable instruments between public bodies, binding corporate rules, standard contractual clauses provided by EU Commission or by a supervisory authority, approved code of conduct, and it is really new, and approved certification mechanism, this is also new, as much as standard clauses adopted by a supervisory authority. Second bucket was the one of usage of appropriate safeguards with prior authorization. This would be the case in case of usage of contractual clauses between controller and processors and others, without those being framed either by EU Commission or by a supervisory authority. And also in the case of provisions inserted into administrative arrangements between public authorities. Finally, EU Council suggested that decisions adopted by the Commission remain in force until amended, replaced, or repealed by the Commission. Finally, the draft retained of Article 42 lays down that in the absence of any adequacy decision, a controller or processor may transfer personal data to a third country or an international organization only if the controller or processor has adduced appropriate safeguards and on condition that enforceable data subjects' rights, but also effective legal remedies for data subjects would be made available. As proposed by EU Council, two buckets are added, the one of appropriate safeguards being used not requiring any specific authorization from a supervisory authority, and the list provided by EU Council is the one appearing in the article. Second, a set of safeguards that could be used but subject to the authorization from the competent supervisory authority. And once again, the two cases provided by EU Council were retained. The supervisory authority shall apply the consistency mechanism, and authorization by a member state or supervisory authority shall remain valid until, as suggested by EU Council, amended, replaced or repealed if necessary by that supervisory authority. All the same for decisions adopted by EU Commission. Let's retain that in recital 83, it is laid down that the controller or the processor is supposed to take adequate measures to compensate for the lack of data protection in third country by way of appropriate safeguards. Classic tools are binding corporate rules, standard data protection clauses adopted either by the Commission or by a supervisory authority, or contractual clauses authorized by a supervisory authority. The availability of enforceable data subject rights and of effective legal remedies is also a key condition for data transfers to be held lawfully. Finally, the authorization of the competent supervisory authority should be obtained when the safeguards are adduced in non-legally binding administrative arrangements. Another provision to retain is recital 79, stressing that the regulation is without prejudice to international agreements regulating the transfer of personal data and including appropriate safeguards for the data subject. Currently, the Directive lays down in Article 26.2 that a Member State may authorize a transfer to a third country not ensuring an adequate level of protection where the controller adduces adequate safeguards with respect to the privacy and fundamental rights and freedoms of individuals, and as regards the exercise of the corresponding rights. Clauses are mentioned as being an appropriate solution. The Member States shall inform the Commission and other Member States about the authorization it grants, and if a Member State or the Commission objects on justified grounds, the Commission shall take appropriate measures. That should entail Member States taking necessary measures to comply with the Commission's decision. It is tightly linked to the debate regarding Schrem's case end of 2015. What should accountable data controllers and processors get prepared for? First, as regarding adequacy decisions, anticipate a substantial change in the assessment of appropriate safeguards and transfers, based on the decision of EUCG in October 2015. Know that transfers without prior authorization in the frame of appropriate safeguards being granted include a legally binding and enforceable instrument between public authorities, binding corporate rules, standard clauses adopted by EU Commission, standard clauses adopted by supervisory authorities, approved codes of conduct, or certification mechanism in the frame of appropriate safeguards being guaranteeing some rights and redress rights. Transfers with prior authorization are contractual clauses being non-standard ones, that is to say, neither adopted by EU Commission nor by a supervisory authority, and provisions to be inserted into administrative arrangements between public authorities. EU Commission adequacy decisions and Member States or DPA authorization regarding transfer shall remain in force until amended, replaced or repealed. Finally, international agreements between the EU and third countries shall apply. Questions now are: what about new international agreements? Will there be any between EU and US? What will be Working Party 29 guidance before EDPB takes place? Will there be a new EUCG ruling? And finally, once GDPR becomes binding, will EU Commission or DPAs adopt new sets of clauses, and what will it look like?